Hello.
Okay, ma'am, are you Megan Wilson?
Yes.
Okay. And sir, are you Michael Wilson?
Yes, I am.
Okay, we'll go on the record now. This is Wilson versus Wilson, case number 24-14583. The record should reflect that both parties are present today by Zoom video. This is set for a pretrial conference today. This is a hearing where I just kind of talked to both of you to try to determine whether or not you've been able to reach agreements regarding the division of marital assets or debts, or whether there are things that there are disputes over. So, Ms. Wilson, on your own behalf there, can you tell me whether you and Mr. Wilson have been able to reach any agreements or whether there are issues outstanding?
There are no issues outstanding. We have come to agreements on everything.
Okay, Mr. Wilson, do you agree with that?
Yes, I do, Your Honor.
Okay. All right. So if there's nothing for the court to decide, then I can set this for a final hearing and we can finalize the divorce. Ms. Wilson, this is usually done by the filing party, which is you in this case. There's a final form. It's called the judgment of divorce. You may already have that form or you can get it online. There are a lot of places you can find it. Do you know if you already have that form?
I do. I picked it up today.
Okay. So I'll just need you to fill out that form and make sure that it reflects the agreements that you and Mr. Wilson have made. You need to get a copy of that to Mr. Wilson and a copy and one copy to the court. And if you do that before the next hearing, then we can finalize the divorce at that next hearing. But it's really important that I have that form because I need to sign that to finalize the divorce. Okay.
Okay. Yes, sir.
Did you have any questions about that?
No.
Okay. Mr. Wilson, did you have any questions at all?
No, I do not, Your Honor.
Okay. Then the court will send out the notice of the date and time of that final hearing. It'll be by Zoom, just like we're doing today. So look for that in the mail.
Okay.
And we'll go forward at that time. You're both free to disconnect.
Thank you.
Your Honor, change my address with the court.
I'm sorry, what was that?
Can I change my address, my mailing address with the court through you, or do I have to file a form to get that sent to a different?
Nope, you can change that right now if you'd like to.
Okay. Yeah. It's 302 Alexia Lane, Alexia Lane, and that's Grayling, Michigan. I believe the zip code is 49738.
Okay, I'll change
Can I
Okay,
update my
sounds
billing
good.
address too?
Okay, go ahead.
Mine is 3780 Whispering Oaks Drive. And that's Traverse City, Michigan, 49696.
that. Okay. Yeah.
Okay, we'll make sure we get those changed in our system and we'll send that notice to the addresses that you've just given.
Thank you.
And that's all I have. Thank you. You're both free to disconnect.
Thank you.
Thank you.
All right, Mr. Paul, are you able to hear me okay?
Yes, I can, Judge. Thank you.
Okay, we'll go on the record in West versus Bancourt. This is case number 2314318. The record should reflect that Mr. Paul is connected by Zoom video. And you're appearing on behalf of defendant, is that correct?
That's correct, Your Honor.
Okay. I don't see Mr. Gilbert connected. This was set for a status conference at 1:45. It's now 1:50.
I talked to him yesterday, Judge, and he was planning on attending by Zoom. So I'm surprised he's not here.
Okay, yeah, and I mean, I haven't had issues with Mr. Gilbert not appearing. So I'm open to suggestions. I guess my thought is that the court would simply reschedule this and give Mr. Gilbert the benefit of the doubt. Perhaps he's having some connection problems or something like that. Do you have any objection to that?
I do not. I would like to advise the court of something that I advised Mr. Gilbert of yesterday. We have not made virtually any progress since we last were before you, Judge. And that is entirely my fault. And my fault is engendered by the fact that shortly after we last saw you, I was diagnosed with advanced prostate cancer. So we have hired some new counsel at the office, at my office, and this file will be transferred, I think, on Monday to a new lawyer who will pick up the pieces for me and try to get it in shape.
Okay, all right. Then I think it probably makes sense to adjourn today anyway, even if Mr. Gilbert were here, so that new counsel can get up to speed. So I'll set this for a status conference at the next motion day in December. And if your office can just, file I don't even know if it needs to be a substitution, but an appearance on behalf of the new counsel so that we know who to contact and that we know to switch the names on the docket.
Yeah, we'll be filing a substitution probably the first of the week.
Okay. All right. Anything else for the record today?
Nothing that I can think of.
Okay. All right. Well, I'm sorry to hear about your diagnosis. I hope that the treatment and recovery goes well, and good luck going forward.
Thank you, Judge.
Okay. Thank you. You're free to disconnect at this time.
All right.
Okay, council, we're on the record now in Woods versus Dobson. This is case number 20-13517. If I could just have council put your appearances on.
Lance Sorhoff on behalf of defendants.
Afternoon, Your Honor. Attorney Kyle Ream on behalf of the plaintiff.
All right, we're on the record here today for a status conference in this case. I see the parties did attend mediation a couple of weeks ago. Looks like that was not successful. So on behalf of plaintiff, Mr. Ream, what do you want to do for scheduling going forward here?
Yeah, Judge, unfortunately, there's been a facilitation twice, once early on and once after fair amount of discovery. We're too far apart, and it's not Lance and I. Lance and I get along well. Our clients may need their day in court, as unfortunate as that sounds. Judge, I can tell you, I'm in a big commercial litigation file. I'm actually at Plunkett Cooney in Bloomfield Hills right now. I'm in one of their rooms doing this Zoom. I'm going to be tied up for several weeks in this file, and the rest of my year is pretty tied up. So if you could graciously push this into January or February, I'd appreciate it.
Okay, Mr. Zerhoff.
No, that timing is actually consistent with my schedule too, but I think that there is going to be there should be a dispositive deadline set, because we do plan on filing a motion to have the court heard before there's any trial on the case, at least for some of the matters at issue.
Yeah,
Right.
I have no objection. I have no objection, Judge, to maybe a dispositive motion date to be filed by, and then maybe you would want to wait to set a trial date after that to see what's left, if anything, because I may file something too, depending on what Lance has in mind.
Okay, that's probably a good idea. Has there been a jury demand in this? Is this going to be a jury trial, or is this going to be a bench trial?
I don't believe I requested a jury. It was a prior counsel, Judge, and I don't think it's a jury trial.
There was no
Okay.
jury requested.
All right, okay, well, that'll make trial scheduling much easier as well. So I don't think we do need to set trial dates at this point, because again, without a jury, that's not going to be as difficult as it would otherwise be. So in terms of dispositive motion cutoff, I'd like to have that set for 60 to 90 days, or let's just say 90 days. Either, do you have any objection to that?
No, that's fine, Judge.
And that's filed and heard. So I want to have that put to bed within the next 90 days. And then whenever those motions are set, I'll set it for a status conference at the same time that the motions are noticed up. If for some reason no motions are filed, then the court will set this for a status conference at that 90-day mark, and we'll go forward with trial scheduling at that time. Mr. Ream, any other dates I can address for your side today?
No, Judge, I can tell you, I appreciate you giving Lance and I a long leash. I really appreciate it. When you're tied up in all kinds of cases, it's really stressful, and you can see I'm losing my hair relatively quick here. So I really appreciate it, Judge. I know you've been really patient with us, and I appreciate that. So thank you very much.
Okay. All right. Mr. Zerhoff, any objection to that time frame or any other dates that you want to set today?
No, I think that works. I guess the only thing I would say is that to the extent there's any kind of, we have some limited discovery follow-up that we're doing right now, and to the extent there's any that needs to be done, we can still do that within the 90-day time frame. I assume there's no cutoff right
No
now.
objection.
Yeah. Okay.
Yeah.
All right. Yeah. No problem with that. So I'll send out the date for that status conference at 90 days. I'll just ask counsel, if there are going to be motions, let's get them filed and let's get them set within that time so we can get some rulings and move forward. Other than that, you're both free to disconnect. Thank you.
Thank you. Bye, Judge.
Thank
Bye,
you, Judge.
Lance.
Thank you. See you, Kyle.
Bye.
All right, looks like a council connected. We'll go on the record in Goodale versus Marchak. This is case number 2314356. If I could just have council put your appearances on.
Charles A. Haas, P14486 for the plaintiff, Your Honor.
Max Prokop on behalf of the defendant, Justin Marchak.
All right, I believe this is set for a status conference in this case today. On behalf of plaintiff, Mr. Prokop, can you give me a kind of an update of where things are at and what you'd like to see for scheduling going forward?
I'm actually the defendant, Your Honor, but I could speak to that if you'd like.
Sure, go ahead.
There was a little bit of a delay because we had to actually go so far as to file a motion to show cause to get the records we needed from Munson Grayling Hospital. We do have those now, and Mr. Haas and I are working cooperatively to get this case facilitated. We've chosen a facilitator. We even talked about the possibility of choosing somebody else if we can't get a date soon, because it's just a little bit uncharacteristic of Stu Weiner to not be able to get a date. But I think maybe his assistant was on vacation or something. As simple as that. But from my perspective, the case is ready to proceed to the negotiation phases, and I think we've been working pretty cooperatively.
All right, thank you, Mr. Haas.
Yeah, I would agree with what Mr. Prokop stated to the court, Your Honor. We'll get a facilitator, and we're looking for a December date to have it facilitated.
Okay. All right. I guess my suggestion would be then to set this for another status conference, maybe in January, once the parties have had an opportunity to mediate. Obviously, if you're able to resolve it, we can always take that date down. And if not, then we've got a next date to discuss how to go further. Mr. Haas, do you have any objection to that?
Not at all, Your Honor. Thank you.
Okay, Mr. Prokop?
If we could do late January, just to give ourselves a little more time, it seems like a lot of the facilitators are running further out these days.
Okay, sure. Yep. I think that's reasonable. Okay, Mr. Haas, anything else I can address for your side while we're on the record today?
Nothing at all, Judge.
Mr. Prokop?
Nothing, Your Honor.
Okay, I'll send out a status conference order that reflects what we've discussed here today, along with a notice of date and time for that next status conference, and you're both free to disconnect. Thank you.
Very good. Thank you, Your Honor.
Thank you, Mr. Prokop. See you.
Sure thing. Take care. Bye-bye.
Judgment.
No, it looks like these guys have
Oh, some issues.
mediation coming up, so. All right, looks like we have both counsel connected. If you can both unmute, we'll go on the record. This is Tanner versus Tanner, case number 2414557. If I could both have you put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Anka Pope on behalf of plaintiff Douglas Tanner, who is also present via Zoom.
Your Honor, my name is Craig W. Elhart. I appear today on behalf of Ms. Tanner, who is also present.
All right, thank you. This is set for a status conference today. In this case, I just looking at the file, I see the parties. It looks like you're scheduled for mediation on November 19th. Is that correct?
That's accurate, Your Honor.
Okay. I guess my thought would be to just push the status conference out to give the parties a chance to see if this could be resolved through mediation. Is there any objection to that?
Not at all, Your Honor.
No, Your Honor.
Okay. So the court will send out a notice of the date and time for that next status conference. If the parties are able to resolve things through mediation, we can use that as a time to take proofs and enter the judgment. And if not, we can discuss how to further proceed. Ms. Pope, anything else that I can address for your side while we're on the record today?
Briefly, Your Honor, I believe we are scheduled for pre-trial hearing today. I know that we went ahead and scheduled ourselves for mediation just because we wanted to get ahead of everything and be on a schedule with a mediator. But I don't know if we need to establish any discovery deadlines and any of the other matters that should be scheduled.
I think I'd just like to leave discovery open for now and just see where you guys go with mediation since that's coming up so quickly. And I can probably get this, on for December. So to the extent that there aren't any agreements reached, we can talk again and set up some dates pretty quickly. Do you have any objection to that?
No.
Okay. Mr. Elhart?
Of course not, Your Honor.
Okay. Mr. Elhart, anything else I can address for your side today?
No, Your Honor, thank you. You've been very courteous today.
Okay, all right, thank you. Both sides are free to disconnect and the court will send out notice of the date and time of that next status conference to you and to your clients.
Thank you, Your Honor.
Thank you. to do that comment case first.
Oh, okay.
All right, sir, is your name Clint Connor?
Yes.
Okay, and then we have another individual, Mr. Kendall. Which case are you signing in on?
On this one, Your Honor, I am Clint Connor's realtor.
All right, are you a party to this case?
No, I'm not.
Are you an attorney?
No, just interested party as we have it's under contract, so I was, kind of helping them out with this.
Okay, since you're not participating in the hearing, I do broadcast to YouTube. You're free to watch it on YouTube, but I am going to remove you from the virtual courtroom at this time.
Okay, I understand. Thank you, Your Honor.
Thank you. All right, we'll go on the record. This is Connor versus DeBo. This is case number 2414535. The record should reflect Mr. Connor and the plaintiff is present. This matter was set for hearing at 2:30. I do not see the defendant present in the Zoom courtroom. Mr. Connor, this is your motion for default judgment. I did review the file. It does look like you properly served the summons and complaint that the defendant was defaulted and was provided with notice of the date and time of today's hearing. Again, they have not appeared. So in my view, you are entitled to a default judgment. You would need to file that judgment with the court. And once you file that, I will sign that and you can get a copy of that here at the courthouse. Did you have any questions?
So I need to bring in the default judgment form?
Correct. Yep. Today was a hearing to make sure that the other side, that nobody on behalf of Robin DeBo or Robin DeBo themselves showed up to contest this. Since they haven't showed up to contest it, then you are entitled to your judgment. But that is the final document that you would need to file that will close the case and give you the relief that you're requesting with regard to the title.
Okay. Sounds good.
Okay. Did you have any other questions?
I don't think so.
Okay. All right. Very good. Thank you. You're free to disconnect. And again, you just need to make sure you follow up with submitting that judgment, because otherwise this case is just going to stay open. And I think you probably want to get done what you need to get done. So filing that judgment is going to be very.
We're trying to close on the 7th, which is Thursday, I think, on the property.
Okay, so yeah, you're going to want to submit that judgment then prior to that so I can sign it, because you're going to need to have a judgment signed by the court.
Yep.
Okay.
Yep. Thank you.
Okay. Thank you. You're free to disconnect at this time.
Thank you. Have a good day.
Thank you. Okay, ma'am, can you tell me your name, please?
Kimberly Kathy Campbell.
Okay. All right, we're on the record now in Campbell versus Campbell. This is case number 2414582. And we have Miss Campbell present here by Zoom video. And just give me 1 second to look at the file here, Miss Campbell, okay?
Okay.
Okay, so I have this set for a final hearing on a judgment of divorce. Is that how you wanted to proceed today?
Yes,
Okay, are you still asking the court to award you spousal support or alimony?
alimony if possible. I know he quit his job on purpose, so I wouldn't get it if that is relevant.
Okay, so that adds a little bit of a wrinkle here, because in order for me to award you alimony or spousal support, then I need to take some evidence regarding your income as well as Mr. Campbell's income, even though he's been defaulted in this case and he can't contest an award of alimony. What is an issue is the amount that the court would award to you, and I need to have evidence as to incomes, because I can't just award an arbitrary amount. I have to have some basis for the amount that I would award and for how long it would continue.
Then can I just proceed with the divorce?
You can, but if we proceed today, you would not be able to come back later and ask the court for alimony.
That's fine.
Okay. Are you sure? Do you want to have some time to think about that? I don't want you to make any rash decisions today that you can't undo, later. So I'm willing to postpone this if you'd like to think about that.
No, I would just like the divorce.
Okay. All right. So I did review the file. You did properly serve Mr. Campbell with the summons and complaint. He did not file an answer. You did enter a default against him, and you've provided notice of the date and time of today's hearing to him, which was 2:30. It's now 2:40 by my clock, and he has not appeared. So I can finalize your divorce today. What I need to do is place you under oath, and then I'm going to ask you a series of questions. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you could raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Ms. Campbell, you filed a complaint for divorce in this case, and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Kalkaska County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
So as I indicated, if you elect to proceed here today without a hearing as to spousal support, that's something that you would be waiving forever and that you would not be able to come back later and ask the court for that. Do you understand that?
Yes.
Have you already divided up all the property between you and Mr. Campbell?
Basically he got everything and I got nothing, so yeah.
Okay. Again, if you wanted to contest that, you can do that, but are you sure you want to proceed today?
Yes, I'm sure it's not worth it.
Okay. All right. Do you own any real estate with Mr. Campbell?
I do not.
Okay. All right. The court finds that, oh, I'm sorry. One last thing. Are you asking to have your last name changed?
Yes, I would like it changed back to my maiden name.
Can you spell that for me?
Johnsson.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of Ms. Campbell. The court will grant the divorce. And I'm signing that judgment now, so your divorce is final as of today's date. That also means that your last name will be changed officially beginning today, so you're gonna wanna get a copy of this judgment from the clerk's office here in Kalkaska, so that when you change your documentation and your ID and other documents, they're gonna want to see a copy of this judgment showing that your name has changed, okay?
Okay.
So you can get a copy of that here at the clerk's office.
Okay.
Do you have any questions at all?
Am I able to get the copy today or should I wait a couple days?
Later today?
Yeah, you can definitely get it today. It might take an hour or so I've signed it, but it's got to make its way over to the clerk's office and get filed. So that might
Right.
take a few minutes, but by the end of the
After
business day
3:30
today.
probably, yeah.
Okay.
Yeah, the clerk's telling me anytime after 3:30, you can pick it up.
Okay. Thank you.
Did you have any other questions?
Not that I'm aware of.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you. Oh.
Warm too.
Yeah.
Mr. DeLuca, are you there? Mr. DeLuca, are you there? Mr. DeLuca, I see that you're connected. Are you able to hear me? All right, I think we may be having connection issues because I see Mr. DeLuca is connected, but his video does not appear to be working. And even though his microphone was unmuted, I'm not able to hear him. So the court is simply I'm just going to pass this for a little bit and let's see what happens. All right, Ms. Hall, are you able to hear me okay?
I am, Your Honor. Are you able to hear me?
Yes, thank you. And I see Miss Kitty is connecting, so just one moment. All right, Ms. Kibbe, are you able to hear me okay? She was there for a second and then she disconnected. So if you could just hang on for just a moment.
No problem.
Sorry about that.
That's okay. Are you Tabitha Kibbe?
Yes.
Okay. We're on the record in CSE Incorporated versus Kibbe. This is case number 2414447. We have Ms. Hall, who's appearing on behalf of the plaintiff, and Ms. Kibbe is here unrepresented in her own behalf. This is set for a status conference in this case today. Ms. Hall, can you kind of tell me where things are at? I believe this case this is simply an enforcement of a judgment from a different jurisdiction. Is that right?
That's exactly right, Your Honor. And Ms. Kibbe and I have done a debtor's examination, and my client is reviewing that information and, kind of deciding what steps it wants to take. Ms. Kibbe was very forthright with information on, there's other parties that are also on the judgment here. There was other parties in another case, there's another judgment that was entered kind of out of that same lawsuit. So we're talking, and so there really isn't anything in terms of date we need. It's just open for collection purposes if and when CSE would want to take any against Ms. Kibbe, but she's been forthcoming, and I'm just discussing with my client on what route they want to take next. And I've been in touch with Ms. Kibbe since the debtor's exam.
All right. Ms. Kibbe, was there anything that you wanted to add to that or needed to state for the record today?
No, thank you. I'm all set.
Okay. I'm going to set this for a status conference at about 180 days out. I need to have a next date set in the calendar in the file to check in. If for some reason we can close this file between now and then, Ms. Hall, feel free to do that and I'll take that date down. Otherwise, that would be the next hearing and the court won't take any further action until that time. Ms. Hall, anything further from your side for the record today?
No, Your Honor.
Okay. All right. Thank you. You're both free to disconnect at this time.
Thank you.
Thank
Bye.
you. Thanks.
All right. Back to Credit Union 1 versus Lund, case number 2414413. Mr. DeLuca has been attempting to connect. He has not been able to do that. He's counsel for the plaintiff. The court will note for the record that Ms. Lund did not appear today. This was set for a show cause hearing. The court will reset this for December. That concludes our